Lisa, just give us a good reset because you were inside that courtroom today. What do our viewers need to know? How did this play out?
Well, Anna, at 9:55 a.m., a deputy called to order today's conference in the case of United States versus Comey and read the case number. But that fact that we started at 9:55 and not 10 a.m. as scheduled tells you everything that you need to know about the courthouse behind me. This is the Eastern District of Virginia, famously known as the Rocket Docket, where things move fast and early. And Judge Michael Nachmanoff's handling of this morning's arraignment was no exception to that. But what you really saw today was sort of a study in contrast. Pat Fitzgerald, the former U.S. Attorney for the Northern District of Illinois, over 12 years, spanning two administrations, Democratic and Republican, a long decorated veteran of the Department of Justice representing James Comey today, had many more words than people expected of the usually taciturn Pat Fitzgerald. And on the contrary, we heard sort of relatively little from the government. And that's because the government was represented in court today, not only by the U.S. Attorney Lindsay Halligan, who did not say a word to the judge, but by two new prosecutors that only entered appearances in the case this week, Tyler Lemons and Gabriel Diaz. They were brought in from the Eastern District of North Carolina, not the office that's adjacent to this courthouse or even across the river in D.C. That's because, according to reporting from our colleagues, there is no one in the Eastern District of Virginia that was willing to take on this case, a case that veteran prosecutors in this office recommended never be brought. We have a two-count indictment charging James Comey with one count of misstatements to Congress in connection with some September 2020 congressional testimony before the Senate Judiciary Committee, and another much more nebulous count charging him with obstruction of Congress for additional false misstatements that are not enumerated in the indictment. So one of the discussions today was Pat Fitzgerald really asking the judge to make sure that the government is sort of meeting its burden to disclose what this case is even about. For example, who are persons 1 and 3 mentioned in the first count of the indictment? Also asking for paperwork relating to the appointment of Lindsay Halligan, the interim U.S. attorney. Why is he asking for that? Because he told the judge that he intends to make two motions right off the bat on October 20th. One, alleging that Jim Comey was selectively and vindictively prosecuted in retaliation for speaking out against President Trump. And secondly, because Lindsay Halligan, according to them, was unlawfully appointed as interim U.S. attorney, and therefore they need to see how she was appointed, when, and by whom. All in all, we have a trial date now of January 5th. Again, I mentioned this is the Rocket Docket, where things usually move fast, and sometimes even within that 70 days afforded under federal statute for defendants to have a speedy trial. Judge Nachmanoff was reluctant to let it go beyond the speedy trial clock. That would have set a trial of December 17th. But because of the defendant's own preference for pretrial motions and the government's representation about the complexity of discovery here, as well as the presence of some unspecified classified information, he said he'd be willing to let that trial date slide to January 5th. Whether we get there on January 5th is going to be a bumpy road between here and there.
Ken, you've been following this case from the very beginning and have been out front in the reporting about an indictment coming and what has transpired since. What stands out most to you about how things went this morning?
Well, I just think it's so interesting that James Comey's lawyers are telling the judge, we don't know what this case is about, really, because none of the rest of us do either. I mean, we have some reporting that suggests what we think it's about. It's about James Comey saying that he never authorized an FBI employee to be an anonymous source in the press. And this indictment contends that, in fact, they have some evidence that he did that. Although the key witness, apparently, a man named Dan Richman, is not saying that. That's not his account. So he won't be a good witness for the prosecution. So, again, it just raises a host of questions about why we're even here, why this case has been brought. And then I'm also just, one thing we haven't heard much about is the fact that, James Comey, this wasn't just an arraignment. He surrendered today. And remember, we talked about this earlier, there were people in the Trump administration that wanted him to be arrested and perp-walked. And a particular official in the FBI in the Washington field office said no to that and stopped that from happening. And that person has been fired. And so today, when he entered the courthouse, we believe, we don't have any information about this, that he would have been processed by the marshals and potentially fingerprinted and his mugshot taken. Again, this is the former director of the FBI, a former senior Justice Department official who firmly believes he's innocent and should not be in this courthouse. It's just a remarkable place we are in our country today.
Anna, can I add something to that to underscore the point that Ken just made?
Yeah. Go ahead.
In addition to the fact that originally the administration wanted to seek Jim Comey's arrest, usually at an arraignment, there are a couple things that happen. One is that the defendant makes a plea of guilty or non-guilty, and Jim Comey pled not guilty today. But the other thing that happens is usually there's a discussion about the terms of the defendant's release. And when Judge Michael Nachmanoff of the Eastern District of Virginia asked the government if they were seeking to detain Jim Comey pretrial, the answer was a very simple no. There were no disagreements on the terms of his release. He was released on his own recognizance. And there are very few limits on what he can do from here on out as a defendant. That stands in marked contrast to the fact that they wanted to arrest him with his indictment.
Thank you, guys. Stand by. Ken, thank you so much for being with us. Lisa, please do stay with me. I want to turn to Anthony Coley here at the table because a lot to digest.
Right.
Your initial impressions of how this went today.
Well, I think it's a sobering moment in modern American history. It's a watershed moment even. Not since Watergate, Anna, have we seen a president weaponize the Justice Department to go after his political rivals. Now, he talked about this in his first term, and even back in that campaign, you know, you remember those chants, lock her up, about Hillary Clinton, but he had people around him who resisted his worst instincts. That's not what we have here. Now, big picture, you know, I've been around Washington a long time. Generally speaking, there are two types of investigations that come out of Washington. You've got the criminal and the civil investigations that you typically see in the Justice Department, where you have, in those situations, you have FBI agents, you have investigators. They just follow the facts.
Yeah.
The facts in the law tell them where to go next. With political investigations, and we typically see this with political actors in Congress, right up the street, members of Congress, they start the process with the end in mind. And then they take a series of steps to try to bring about the political outcome that they want. And that's what Trump has done here. He has corrupted the Justice Department and put aside facts and law and replaced it with revenge and vengeful politics. That's what's going on right now.
Paul Butler, what do you see as this case being in terms of strong or weak? We had initial impressions when the indictment was brought, but given what happened inside the courtroom, some of the conversations that took place between the judge and the lawyers, does it give you any more confidence that this could be a legitimate prosecution?
I think this is an extremely weak case, Anna, and if you don't believe me, ask the prosecutors and investigators who investigated this case. Reportedly, Eric Siebert would have loved to have won this case on behalf of his boss, Pam Bondi, and the President of the United States, Donald Trump, who urgently wanted this prosecution. But the experienced prosecutor said if this case goes to trial, he's going to lose. And that's why he declined to bring it. His reward was he got fired by the President of the United States, who bragged that he was going to get the guy he wanted. And in order to do that, he installed this extremely unexperienced prosecutor to bring this high-profile, very tough case. So to me, one of the most telling moments this morning was when the very experienced defense attorney for Mr. Comey, Pat Fitzgerald, said he was going to bring a motion for prosecutorial misconduct. Anna, that's a nuclear option for a defense attorney. It means that he or she believes that the prosecutor violated the law or professional ethical standards. It's usually brought when prosecutors are accused of presenting false evidence or withholding evidence. So this is going to be a heated battle, and I'm fairly certain that Mr. Comey will prevail, either by getting the case tossed out or by getting a quick verdict of not guilty from a jury.
So because Halligan defied the advice of every other prosecutor in her department by bringing this indictment, Paul. And because the statute of limitations ran out more than a week ago, as it pertains to that testimony in 2020 with Comey that they say is the crux of the case of proof he lied, is there any chance if this is thrown out that it could be like resubmitted? You know, if they go back and try to rework the case a bit?
So the prosecutors don't get a do-over in terms of an indictment here. They do get to go to the grand jury a couple of times, which is what happened in this case. And apparently with the first indictment that this inexperienced prosecutor presented, the grand jurors balked with regard to one count. And so then she brought another indictment. One interesting point was that when she was questioned about this in the original presentment of the indictment to the judge, this prosecutor didn't know that she'd signed one indictment that the grand jury had refused to indict the case. That was news to her when the judge told her that she'd signed it. So this demonstrates how inexperienced this prosecutor is. So the motions that will first be filed are motions for selective and vindictive prosecution. Those are usually dead on arrival. Vindictive prosecution means that defendants have to prove that prosecutors displayed some kind of animus toward them while they were seeking to vindicate their rights in court. And selective prosecution means that the defendant has to prove that prosecutors discriminated against them by failing to bring charges against similarly situated individuals. So it's usually brought by people who say they're being treated differently because of race or gender or religion. Comey's motion for selective and vindictive prosecution doesn't fit neatly into either of those boxes. But one difference about this case is the mountain of evidence about political motives by Trump and by Bondi, who reportedly agreed with Siebert that this was a losing case, which means under DOJ regulations, she shouldn't bring it, but she allowed it to be brought anyway.